Okay, hello everybody. She did respond. We have we've got a response from the judge. We also have a response back from the government. We've got two things just came out. They're moving quick. They're moving quite quick along here. So, oh, did you? Okay, good. This just came down. Yes. Oh, welcome everyone. All right, so I'm going to just dive right on here, dive right in. We had our response to motion that was filed by the defendant today by 5 o'clock, and he had some suggestions, things he wanted to have changed, and what's happened since then was the government filed a response to that motion, which is here. So I've not really had much of a chance to go through it, so I thought we could go through it together here. This is only a couple pages actually, but the government did respond to his motion, and then the court set it for a hearing. So I won't leave anyone hanging here, but this is what has already been filed. We had a response by the defendant regarding the motion. We had a reply, and I'll go through that with everyone here. So we reply by the government, and then we've got the court here, and the court is setting out, upon consideration of the government's 10 motion for a protective order and defendant's 14 response, as well as the government's reply, the court will schedule a hearing on the parties' respective proposals. The court will waive the requirement of defendant's appearance. Accordingly, it's hereby ordered that no less than 3 p.m. on August 8th, the parties shall meet and confer and file a joint notice of 2 dates and times on or before August 11th, when both parties are available for a hearing. So she has set out, hey, you guys need to get together and pick some days and set up some times for those hearings. So, good, yes. I will go through the government's motion, their response, just to give everyone a heads up, because again, this was just filed, so we don't have, I don't have much more information about it than any of you, but wanted to just kind of hop on and look at here what the government's response was. So just a couple hours ago, we had defendant's response, and now we've got the government's response. And then the judge just set out a time that she wants everyone to sit down and talk about it. So let's go through the government's response then. Oh, I got my nail polish color. Oh, no, that's fine. It's a couple of colors, actually. That's, I can't remember. That's terrible. But I've got just a base color and then kind of a sparkly top coat. So I will bring them with me next time so that I've got, I can share that with you all. But thanks for requesting. That's sweet of you. So yes, we've got, yes, I play guitar, so I keep my fingernails very short, and have no problem with that. So, yes, what are we doing? We are going through the government's response. Now, just again to update everyone real quick, and then I'm going to dive right in here. We've got the response by Mr. Trump for the opposition to the government's motion for a protective order. That was all very controversial over the weekend. And now we've got the government's response to his response. And then we have the judge who's ordering a hearing to talk about it. So I will go ahead and just dive right in. I'm not going to go word for word for everything in the government's motion here or response, but I think there's a few good points to kind of go through here. So just because you can print out paper doesn't mean you're an attorney. That's true. It doesn't. Yep. Oh, thank you. That's sweet of you. Yes, it's true. If people are if you're not interested, you can feel free to swipe on by. Just here. I'll think about it. Let me. I'm gonna take a few more minutes here. If I hit, what I'm noticing really is about. I can get to about 7:50, and then after that, I need my mods to come in, and my poor mods are so tired. They've been working so hard. I'm so thankful to everyone and those who are volunteering as well. So I may come in and ask for some help here in just a little bit, but we'll see how it goes. Let me go ahead and just dive right in to the paperwork here. So the central purpose of criminal discovery is to provide the defendant with materials necessary to prepare for a fair trial. To facilitate the efficient production of discovery to the defense, the government proposed a reasonable protective order consistent with current practice in this district. The defendant instead proposed an order designed to allow him to try this case in the media rather than in the courtroom. To safeguard witness privacy and the integrity of these proceedings, the court should enter the government's proposed protective order. So here's our background. Now, I'm not going to go line by line through the background here, but I think there are some good points that the government's bringing up, as, of course, defense had brought up some good points as well. So filed the motion for a protective order on Friday, and then on Saturday, the court entered the minute order requiring a response by Monday, which is what we just had here. On Sunday, defense counsel appeared on 5 television programs and discussed this case in detail, publicly commenting on topics including the parties' disagreement over the protective order. That's a pretty significant statement there. The defense's planned legal arguments, the defendant's actions and statements during the charged conspiracy, and expected testimony of prospective witnesses. So that's a lot. I heard little sound bites of what was going on over the weekend, but there were a lot of legal arguments that were presented by his attorney and even case law that was cited, which is actually relatively unusual. I mean, that's great if you're the prosecutor because then you can see what the defense is going to argue, but as well as their case law, so you can prepare the other side. But yes, and this was his attorney that was talking. So it wasn't Mr. Trump. It was his attorney going on and talking about that. For instance, regarding the protective order, the defense counsel stated on CNN, quote, "This protective order that's being suggested by the Biden administration is an effort to keep from the press important non-sensitive information, and we will not agree to keeping information that's not sensitive from the press. The press and the American people in a campaign season have a right to know what the evidence is in this case, provided that this evidence is not protected otherwise. So we're going to oppose it as we have. But for whatever reason, these lawyers on the prosecution team want to keep them from the press," end quote. Defense counsel then suggested that the government, by its proposed protective order, was, quote, "trying to impinge on the freedom of the press," end quote. So, I think we all kind of predicted that this might happen, that any of that language absolutely can be used in a motion. And that's what the government's doing here. They're using direct quotes from interviews that were given with the press over the weekend, going into the fact that they've got concerns that information is going to be made public. So, and it was. So we've got next on ABC, "This is an attack on you and the members of the press. I'm really surprised people haven't spoken out about it. What the Biden administration is trying to do is prevent the press from learning about exculpatory and helpful information, evidence that the people have a right to know about. What the position of the prosecutor is non-sensitive. Ordinary evidence should not be disclosed to the press. That's shocking. Not only do they want to violate President Trump's First Amendment rights, they want to violate freedom of the press. And I'm surprised that the major networks aren't filing papers along with me on Monday." Defense counsel then suggested he could, quote, "get the ABC reporter a lawyer," end quote, to engage in litigation over the protective order. So that's another set of quotes directly from defense counsel over the weekend. On NBC, well, I'm shocked, and I can find you a lawyer to address this, but I'm shocked that all of the news media outlets aren't protesting what the government's trying to do. They're trying to say that we have discovery that's not sensitive, but we don't want the press to hear about it. And Mr. Trump, our team, is saying, President Trump is saying, that if there's evidence out there that the government has that's exculpatory or informative, then the press has a right to know. But the Biden administration doesn't want the press to know that. And I'm shocked that there aren't petitions now filed in the district court opposing what the Biden administration is doing. So that, again, is some pretty significant information added in here. On CBS, we're all in favor of protecting sensitive and highly sensitive information, but it's unprecedented to have all information hidden in a criminal case, including, by the way, information that might be exculpatory and might be exonerative of President Trump. The Biden administration wants to keep that information from the American people, end quote. Okay. Now, again, I did already do a live on special counsel and how they are pulled in from the Attorney General, so we don't, I won't go into that again, but that's how they're chosen. And then last, on Fox, the Biden administration wants the judge to put in place an order that will prevent the press from obtaining exculpatory and material information that might be relevant to these proceedings, even though Mr. Trump, President Trump, has argued from the very beginning, as I have, that this is an attack. This indictment is an attack on his First Amendment rights. Now, what the Biden administration wants to do is deny all Americans the opportunity to learn non-sensitive information about what the case involves in a political season, end quote. Defense counsel continued, quote, I'm convinced the Biden administration does not want the American people to see the truth, and that they acted on it by filing this protective order. Wow, that's pretty harsh, which is an effort to keep important information about this case from the press. I'm shocked that all networks haven't lined up and filed pleadings already, objecting to this very broad attempt by the Biden administration to keep information away from the American people during the election season. The American people have a right to know. Of course, Joe Biden doesn't want that to happen, end quote. So that's a lot. That's a lot. All the exculpatory evidence will be heard during the public trial. Yes, it will be. Yep. Of course, that all comes out. So these are direct quotes from defense counsel. So that's pretty significant. All right. In television appearances, defense counsel also made specific claims about what the defendant allegedly said and did during the charged criminal conspiracies, which is a pretty big thing to note, and discussed anticipated testimony of Mike Pence. So they talked about anticipated testimony of a key witness, stating on ABC that the former vice president would, quote, be one of our best witnesses, end quote. And on CBS that, quote, the vice president will be our best witness, end quote. And then we've got an additional piece down here in the footnotes. The defendant himself has made a number of additional social media posts related to this case since the government filed his motion for a protective order. For example, the day before his counsel made comments about Mr. Pence, the defendant posted the following to social media. Wow, it's finally happened. Little Mike Pence, a man who was about to be ousted as governor, Indiana, until I came along and made him VP, has gone to the dark side. I never told a newly emboldened, not based on his 2% poll numbers, oh, that's kind of mean, Pence to put me above the Constitution or that Mike was too honest. He's delusional, and now he wants to show he's a tough guy. I once read a major magazine article on Mike. It said he was not a very good person. I was surprised, but the article was right. Sad. Oh, that's mean. Yes. Sorry about that. You have to let me know if that's better. But yeah, the feelings police, exactly. The feelings, and get the guitar out. Definitely. There we go. Is that better? Is that better in frame? Yes, you're welcome. Absolutely. Yeah, so he already made a statement about a witness that was involved. So I know the footnotes are back. Strums a sad song. Thank you. Yes, for the accompaniment. All right, here we go. Back up. There's our footnote. Back we go. On Sunday afternoon, the parties conferred twice by phone. Defense counsel also shared a red line of the government's proposed protective order. With the parties unable to reach agreement on a proposed protective order, the defendant filed his proposed protective order on Monday. Here's their argument. The defendant's proposed order would lead to the public dissemination of discovery material. Indeed, that is the defendant's stated goal. The defendant seeks to use the discovery material to litigate this case in the media, but that is contrary to the purpose of criminal discovery, which is to afford defendants the ability to prepare for and mount a defense in court, not to wage a media campaign. The court should instead enter the government's proposed order. It really is. And one of the reasons why I just continue to come on is, of course, this is going to be the biggest trial of my entire life that I'm witnessing. I was not around in a proper legal capacity to kind of comment and go into the O.J. Simpson case. So this is the biggest case that I think I'll ever be watching. So let me just make sure that I'm in frame again. I'm just keeping an eye here on the comments. Am I in frame okay? All right. And we go back in. The government's proposed protective order applicable to all, thank you very much, applicable to all discovery produced by the government is consistent with others routinely entered in criminal cases in this district. And then we've got case law cited here. So, and specific protective orders also cited. Protective order governing discovery, number 14. So these are all examples. The defendant's principal objection to it, as defense counsel stated publicly yesterday and in conference with government counsel, is that it would not permit the defendant or his counsel to publicly disseminate and publicize in the media various materials obtained from the government in discovery. But there's no right to publicly release discovery material because the discovery process is designed to ensure a fair process before the court, not to provide the defendant an opportunity to improperly press his case in the court of public opinion. And we're citing U.S. v. Cordova in this case. So, in that case, is holding a trial court can and should, where appropriate, place a defendant and his counsel under enforceable orders against unwarranted disclosure of the materials which they may be entitled to inspect. And again, we're quoting Alderman. Now, this is a direct quote again from the government's initial motion that they filed for a protective order. So these are the same cases that they've pulled here, noting that discovery rules are a matter of legislative grace and litigants have no inherent rights to disseminate what they obtain through this discovery process. And then that bumps us down to number 2. The defendant contends that strict scrutiny should apply. Well, that will be interesting. I was wondering if they were going to address that First Amendment issue. The defendant contends that strict scrutiny should apply to the review of the protective order. The Supreme Court has stated otherwise. See Seattle Times, and they're quoting the case here. It's significant to note that an order prohibiting dissemination of discovered information before trial is not the kind of classic prior restraint that requires exacting First Amendment scrutiny. Okay, so they're citing case law here, talking about that First Amendment. All right, so back up we go. Defense counsel's stated goal to publicly disseminate and discuss discovery materials in the public sphere is contrary to the general principle against pretrial publicity and inconsistent with this district's local rule regarding conduct of attorneys in criminal cases. Oh, let me try to straighten this out again here. Here we go. There we go. Hopefully that's okay. I'm trying to not trigger anyone with my crooked paperwork here. Okay. So with local rules with regards to attorneys in criminal cases, and the court should not enter a protective order that permits such harmful extrajudicial publicity. As an initial matter, the court can and should exercise its discretion with respect to the protective order to prevent dissemination of discovery material that could prejudice the jury. Citing case law here, where the holding was a trial judge has an affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity. Citing more case law here in the Brown case, other principal dangers of pretrial publicity include disseminating to the press inadmissible evidence, which is very true, the exclusion of which at trial is rendered meaningless when news media make it available to the public, as well as creating a carnival atmosphere which threatens the integrity of the proceeding. And this is a quote out of the Maxwell case. The district's rules prohibit defense counsel from doing precisely what he said he has stated he intends to do with discovery if permitted. Publicize outside of court details of this case, including the testimony of anticipated witnesses. Local Criminal Rule 57.7 sub B provides that it is the duty of attorneys in criminal cases not to publicly disseminate information or opinion regarding, among other things, quote, the existence or contents of any statements given by the accused or the identity, testimony, or credibility of prospective witnesses. And that's so essential because our juries are our fact finders. And so if they are given a whole bunch of information before they're even shown what we show them in trial, that could be a problem. This is because such statements risk tainting the jury pool with inadmissible evidence or otherwise harming the integrity of these proceedings. Citing case law here, the court should not grant a protective order that would allow defense counsel or the defendant to disseminate evidence such as snippets of witness interview recordings, no matter how short, misleading, or unlikely to be. We're coming down to the final parts of the government's response here. Just trying again to keep this in frame for everyone. Admissible at trial under the federal rules of evidence and claim that it supports some position the defendant later may make in pretrial motions or at trial. And that's true. All of our motions in limine, all of that information, or even motions to suppress, any of that, when they've got rulings on that, if that evidence is out in the public, but then they restrict it for the jury to see, that could be pretty significant. Such conduct has the potential to unnecessarily inflame public opinion, short of all relevant facts, intimidate witnesses, pollute the jury pool, and in general degrade the integrity of proceedings in this court. The goal of the defendant's proposed protective order, prejudicial publicity, is antithetical to the interests of justice, in addition to the general principle that the court should enter a protective order that prevents public dissemination of discovery in this matter. The government below sets forth certain other specific deficiencies in the defendant's proposed protective order. So now we're going into what they think were some of the problems with his protective order suggestions. So I'm not going to spend a lot of time going word for word through this specific problems because, again, this is something that needs to be argued out in front of the judge, and she has said that. But they do. They have problems with unrelated to discovery process, other attorneys assisting counsel of the record. I think we talked about that before. A defendant proposed replacing language regarding persons employed to assist the defense. We kind of talked about that before also. So these were all kind of issues that I think we all knew the government would probably have with what was going on with his motion that he filed. So let me make sure I get this in frame properly again. Removing from the definition of sensitive materials, recording transcripts and interviewing. Now, I would say this is probably one of the most significant pieces. Interview reports, related exhibits of witness interviews. In a meet and confer conference, the government clarified to defense counsel that the government intended to produce in discovery transcripts and audio recordings of witness interviews conducted outside of the grand jury process. The defendant thereafter maintained his proposed edit, an edit that would allow the defendant to release to the public these recordings, transcripts, and interview reports. the defendant's position here makes clear that the defendant's intention to try this case outside of the courtroom. The court should reject the defendant's proposed modification. So that's another piece of it. Now, the next part they're talking about was the removal of the information given to other congressional bodies. For the same reasons, that would be inappropriate to allow defense counsel to publicly disseminate transcripts of witness interviews conducted by the government. It would also be inappropriate to permit dissemination of witness interviews conducted by other government entities. And then that bumps us down here, which I think is a really good point. As a practical matter, most, if not all, of these interview transcripts and recordings are covered only by Federal Rule of Criminal Procedure 26.2. That is to say, the government's under no obligation to produce these materials at this stage in the proceeding. So that's kind of one of those, like, we want to give you this information, but if you're going to fight us about it, we're not going to give it to you. So that's kind of this back and forth that's been going on. At the end of paragraph 8, defendant proposes that the government conspicuously mark all such sensitive materials, presumably on each page of each such document. The defendant's proposal is logistically unworkable and would serve to delay the government's production of discovery. Instead, the government's proposal contemplates clearly defining sensitive material in the cover letter and or source logs accompanying the discovery productions, thereby eliminating needless delay and getting the defendant the discovery he claims he wants. And in paragraph 10, defendant seeks to prohibit his counsel from confirming that his notes do not contain personally identifying information, subject to rule of Criminal Procedure 49.1. That's that confidential private information. But this condition, which is included in the protective order on which the defense claims to model his proposal, is particularly important here because the defendant and his co-conspirators practice, as described in the indictment, of publicly targeting individuals. So that's some pretty harsh language here with that. So, and then we get to the very last piece here of the government's response to the, let me make sure I'm in frame. Hopefully I'm in frame. This is from the government. This is the government's response to defendant's response. So in the last piece, the defendant's edits to paragraph 11 through 13 are inappropriate. The new paragraph 11 is in direct contravention of Local Criminal Rule 49F6 I. The additional edits to the new paragraph 12 and 13 unnecessarily complicate what the government's proposal makes straightforward. Should trial procedures later necessitate a modification of the protective order, such modification is expressly contemplated by paragraph 13 of the government's proposed order. The court should accept the government's proposal. And conclusion, government has proposed a standard, reasonable order that will streamline the flow of discovery to the defendant while preserving the integrity of these proceedings. The defendant has proposed an unreasonable order to facilitate his plan to litigate the case in the media, to the detriment of litigating this case in the courtroom. Normal order should prevail. No oral argument is necessary. Well, that's harsh. The court should enter the government's proposed protective order. Signed, Jack Smith. So there we go. That's the government's response, again, to defendant's response to the protective order that was set out just today. And then finally, to bring everybody back to where we were here, let me make sure I'm in frame properly. We have the response by Mr. Trump today. We have the reply by the government. And then now we've got this order where the judge has said, upon consideration of the government's motion, as well as the government's 15 reply, the court will schedule a hearing on the parties' respective proposals. So she's ordering here that no later than 3 p.m. tomorrow, the parties shall meet and confer and file a joint notice of 2 dates and times on or before August 11th, when both parties are available for a hearing. So that is the order then that has come out. So what does the plain meaning say? Well, she's saying we need to pick some days to argue this out. So you need to get together before 3 p.m. tomorrow or contact each other and, talk about your schedule. So this is a scheduling issue where she wants to say, when are the parties available for a hearing? So let me know. And then once they come to her with those dates and times too, so 2 different dates and times, then she will probably set that hearing. Yeah, she's not messing around. She's like, let's just we need to get this taken care of. But she is setting it for hearing so that they can argue it out. And that is what defense counsel wanted. The government said it was unnecessary, but, the judge is saying, fine, let's have a hearing on it, but you guys need to get together, pick out your dates, and we need to get it on the docket. Yep. Yep. Of the defense's argument, it's hard to summarize. Let me see what I can do. Defense's argument he had said, first of all, we've got First Amendment violations, that the government's trying to impede his First Amendment rights. And then also frustration with how quickly he had to respond. And then also citing that they're trying to do this as a political reason rather than a legal reason. And again, First Amendment issue going on, which is really not applicable legally. So he spends a lot of time explaining First Amendment strict scrutiny, although not applicable. Then it does take some time to come in and explain what he wants changed in the government's proposed order. So changing of authorized persons, procedures for sensitive documents, definition of sensitive materials needs to be changed. So they've kind of crossed out and added some various pieces that they would like to see changed. So based off of that, and I think really the bottom line in his argument is he doesn't think all of the information is sensitive enough that it needs to be kept out of the public. So I think that would summarize really his point of view. The government is saying that, there is sensitive information that needs to be kept, and that if it's not, it could be made public. And then gave a few examples of that. So, and then the judge is saying, fine, let's set it for a hearing. Yes, and, I think there's a lot going on here, and we want everything to be as public, as transparent as possible, but there's also some safety concerns. And I think, we do have a history with this situation. I think by the nature of what happened on January 6th, we have some safety concerns. So, I can see where they're coming from on that. So we've got this balancing that the judge is going to have to figure out. We're going to have to balance out safety, but also, we do need some transparency. We do need that. I think everybody needs some of that to happen here. So it is going to be a balancing test. I really don't know why or how she's going to hold, but I can see why she would want to debate. Why is there no sedition charge? I think valid question, and I think it would make everything way more complicated than it needs to be at this point. You can always come back and file a sedition charge, but I think with the extent of this indictment that came out, because it was so information heavy that a lot of people just didn't know had happened, I think they tried to make it nice and neat and clean and efficient to get this to the grand jury. And so I think if we had put in sedition, if we had put in treason, if we had put those other elements in, it really could have gotten things tangled up quite a bit more than what was needed, because it's already going to be pretty difficult. So that's what my thoughts would be on that. We're never allowed to see the Mueller report unredacted. Why should we see top secret reports? They're top secret for a reason. So we do have, we definitely have some limitations on that. Now, what is the canon judge up to? Yes, Norma. Oh, yes. I did print out what was going on. So if anyone's got any last questions here on DC, I will take those, but I do have the documents that were set it's really interesting what's happened. Is everyone ready for Florida? Are you ready for a Florida update now? No, nothing concrete other than the motions that were set, and then the judge saying, look, dudes, we need to set this for a hearing. So, yes, okay, ready, okay. Oh, sure. Okay, never ready for Florida. Isn't that the truth? There's a lot going on. All right, so we had a few interesting things going on in Florida here. I kind of been keeping my eye on it. I print the docket out, and so it's always interesting when something gets submitted onto the docket, but then gets struck from the docket. So it's kind of like this back and forth situation. But when last I went through what was happening, we're going into Florida here. So just to keep everybody up to date, we're now into Florida. So we're putting DC aside. We're going to wait until she sets the hearing. But now we're into Florida. We've got an arraignment for the superseding indictment set for the 10th. And then we had a couple of other things here, waiver for personal appearance. Now, what's interesting, what was just added today is, I'm not really sure exactly why this is being done this way. This, to me, legally is a bit unusual, but we have an order striking sealed filings and ordering a briefing. So she is saying that there are certain filings that were to be sealed for certain reasons by the government, and she's striking it. She's saying they don't need to be sealed, and then she's ordering a briefing for counsel and her. So she's got an order denying 95 seal motion, and the clerk is directed to strike from the docket sealed entries for 95 and 96. Now, if you look over here, this is the number of the documents, and you can see there's this gap between document 94, which is this paperless order, and 98, which is this waiver. So 95, 96, and 97 have been struck from the docket. And she's saying here, clerk's directed to strike from the docket sealed entries 95 and 96. Walter Nata shall file a response on the motion for a Garcia hearing on 97, on or about August 17th. Special counsel shall reply on or before August 22nd, and this was signed by the judge. So she's talking about this Garcia hearing, and all right, so there's a conflict of interest that's going on that is the best I can figure. We have Garcia hearings to come in because there was a case back in the 70s is when it was, where a defendant, if their attorney has some kind of conflict, they can kind of waive that conflict and say, it's fine, I'm not concerned. And so we call that a Garcia hearing, when we pull in the different parties to kind of talk about if there's this conflict of interest for the attorney for the defendant. So this order is literally 2 pages, but let me walk you through it. This other order here is for electronic devices, but it's this 2-page order that is interesting that came out today in Florida. So let's go through this. An order striking sealed filings and ordering a briefing. Again, this idea of ordering them to get together and explain things to the judge is just a little bit different. That typically doesn't happen. This matter comes before the court upon the special counsel's motion for a Garcia hearing. So the government is saying we need this hearing to talk about conflicts of interest. And this is with regards to filings number 95 and number 96, which have been sealed. And if they're sealed, they were sealed by the government for some reason. Of course, we don't know. Of course, we don't have those documents. It is ordered and adjudged as follows. 1, special counsel moves for a Garcia hearing to inquire into the potential conflicts of interest that may arise from attorney Stanley Woodward Jr.'s prior and current representation of 3 individuals the government may call to testify at the trial of his client, Waltine Nata. So there is the conflict of interest question, okay? So his attorney is also the attorney for 3 people the government wants to call as witnesses. So now there is this question if there's a conflict of interest here between him representing Mr. Nata as well as these 3 other witnesses, because they could have different intents and different necessities here. So that's why the government's asking for this Garcia hearing. Simultaneously, the special counsel moves for leave to file under seal a supplement containing additional information to facilitate the court's inquiry. So he's got further information that he would like to file, but under seal so that it's not made public. The special counsel states in conclusory terms that the supplement should be sealed from public view to comport with grand jury secrecy, but the motion for leave and the supplement plainly fail to satisfy the burden of establishing a sufficient legal or factual basis to warrant sealing the motion and supplement. All right, so that's harsh. The judge is coming down on the government by saying that. She's saying you have not given enough support to allow for the sealing of this information. So there's not enough. The special counsel's motion for leave to file under the seal is denied. So she's saying if you want to file this, it's going to be public. It's not going to be under seal. The clerk is directed to strike from the docket the sealed entries 95 and 96. They had already been sealed, but they're being struck, meaning if those documents are going to come in, they need to come in as public documents because the government didn't satisfy the burden, saying that there was a good enough basis to seal the information. And next, Walty Nada shall file a response to the motion for a Garcia hearing. So the issue is because it's Mr. Nada's attorney, he can file a response to the motion asking for this conflict of interest hearing on or before August 17th of 2023. Among other topics, as raised in the motion, the response shall address the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or to seek post-indictment hearings on matters pertinent to the instant indicted matter in the district. Ooh, that sounds harsh. Let me just look at that again. Among other topics, response shall address the legal propriety. So we would call this spoon feeding when the judge is telling the defendant what he needs to include in his motion of using an out-of-district grand jury proceeding. So she's telling Mr. Nada that he needs to raise this legal issue. That's interesting. Sometimes that happens. Sometimes our judges give some hints and some assistance here, but that's pretty clear that she's saying, look these grounds up. The special counsel shall respond to that discussion in a reply in support of the motion, due on or about August 22nd. The remaining defendants may, but are not required to file briefs of their own related to the grand jury issue. Wow, she's bringing this up again. She's telling the other defendants to bring up this issue. So she's not bringing it up herself as the judge, but she's telling the defendants to bring the issue up. All right, interesting. Referenced herein, but any such briefs are due by August 17th of 2021 and may be submitted in combined or individual fashion. And then we've got this request for supplemental briefing is not intended to substitute and or to limit any future motion brought pursuant to 12B. Just a minute, let me just look up. I think that's a motion to dismiss. Let me just look up here. We've got Rule 12. Okay, so pretrial motions, pleadings, pretrial motions. Any pretrial motions, any defense objection, request without a trial on the merits. Okay. So she's saying none of, oh my goodness. Motions that may be made at any time. So that would be lack of jurisdiction motion can be made. Motion made before trial would be objections, requests, pretrial motions, improper venue, pre-indictment delay, constitutional right of speedy trial, selective or vindictive prosecution in an error for grand jury proceeding, defect in the indictment, joining two or more offenses, charging the same offense, lack of specificity, which would be our bill of particulars, improper joinder, failure to state an offense, that's a probable cause issue, motion to suppress, so suppression of the evidence, severance or charge of the defendant, discovery rules, notice of the government's intent to use evidence. So she's saying with this piece, she's saying none of the information that she's saying here is supposed to be used to substitute or limit any future motion. So that's a lot. I think that's a lot for a judge to set out. I've got legal issues that I think you should look up for defendants, and whatever is discovered should not negatively affect any of your motions, like your motions to suppress or your motions to for a bill of particulars and so on. So kind of keeping this to the side, like really quarantining this off. Is a judge allowed to do that? Well, it's a unique order. I think it's a unique order where judicial discretion is being used to the maximum level, and I'm not saying that it can't be done. I'm just saying it's a creative way of setting something out. And I think too, to have the language so blatant of kind of like lobbing this legal issue over to defense to take care of is interesting. We really don't see that at this level in a criminal case. Typically, this would be like an appellate question when you're arguing in front of the judges. They can say, well, hey, did you forget about this? And you're like, yes, that's right, I forgot. But just to have it at this level when we're talking about the other grand jury issues going on, I don't know. It's creative. I think it's green. I think it shows, that she doesn't have a lot of experience, which is, fine. That's fine. That's how we go through things. But this is, it makes me hesitate only because not only is she talking about Mr. Nada, but she's also telling the other two defendants that they can also bring up this issue. Like, who even asked about this grand jury issue? Why aren't they filing their own motions? Why is the judge telling them to include that in their response to a Garcia hearing, which is a conflict of interest hearing? So why is she asking them to include grand jury questions in it? Why isn't it being filed separately? Yeah, no one has asked. I think that's unusual. Right. Yes, we absolutely have no evidence whatsoever that she is not an honest judge or that she cannot do her job. There's no evidence whatsoever that's saying that she's not. What I'm saying is this is creative. It's unusual, but it's an unusual case to some degree. So we do have that, but I don't know. I think maybe she's noticed that the defendants maybe need a little extra point in the right direction. But by doing that, then your impartiality comes into question as a judge, because you're supposed to be neutral. You're not supposed to be helping anybody out. It's one thing if you're pro se, but we've got high-level felonies here with professional special counsel and attorneys. And at this level, you shouldn't really need to be giving hints out to the defendants. But maybe this is her style. Maybe this is just her style of doing things, that she's always wanting to kind of help the defendant out. I don't know. I don't know her background with that. Is there an argument here that she should recuse herself? Not yet, Michelle. I don't think so. I think to hint at defendants or to even say, hey, why don't you guys go ahead and address this issue? Maybe she's just trying to say, let's just get it all out on the table. Let's just play all of our cards and get it sorted out rather than just kind of kicking it around. Let's take care of it. But, maybe that's her motivation, and that's fine. I don't see anything here that's outside of the scope of her authority as the judge in this case. It's not something you normally would typically see, but she is the referee. So, they can kind of set out what the parameters are. And to me, it just looks like there's a lot of things kind of rolled up into one thing, rather than just dealing with the Garcia issue. She's kind of putting this all together. And again, that could be for efficiency or, something else, but we certainly don't have any information or evidence that she's doing anything wrong. It just, it strikes me as a bit unusual. That's why it took a little time for me before I decided to come on and really talk about this, because I was like, it just looks a little bit different. Doesn't necessarily mean it looks wrong, just different. Yes, I mean, if we're dismissing at this point, I don't know what grounds she would have to dismiss. You got to have some kind of grounds, and somebody has to ask for it. I think the fact that she's implying, all of our orders under Rule 12B, I think is, again, if we look at that rule, 12B, a defect in the indictment or information. And so, I mean, there kind of is this implication that there might be something wrong with the indictment, or that it would be worth them filing. But she also might just be saying, hey guys, if you're working on these motions, just so you know, this isn't going to interfere with that. So, I can see both ways. I can see both ways that she would want to kind of go after it. No, it's not. We've got laws. If there's a United States Code section and there's probable cause to believe somebody violated those sections, I mean, we go forward with an indictment. We certainly don't have a proof beyond a reasonable doubt. That's what a trial's for, but she could be trying to get it all out so he can't say he didn't have a chance to say something. That's very possible. Absolutely. That's very possible. It is very possible. I think, we just don't have enough information to really know what kind of her intent or her rationale is on it, which is absolutely fine too. But, it's a lot. It's a lot to pack all together. But, if you think too about what's going to happen, there's a lot going on in this case. There's a lot of hearings. There's a lot of discovery. There's a lot of things. And so if she's like, hey, we've got this question of a Garcia hearing, let's just take care of it. There's this somebody somewhere, somehow this grand jury issue got brought up for some reason. Let's just kind of take care of that too. So I could see that potentially being a reason why. I'm not sure it is. I'm just saying I can see how that could be argued on that. Yeah, and they may need help. That could very well be. And, again, we're trying so hard to make sure that our defendants get a fair trial. If she feels like, this has to be brought up in order for us to have a fair trial, let's just get it done, get it out of the way. That could very well be her rationale for it. It could be. It's just hard to, I'm not really sure what that would be. How experienced are you in political prosecutions of former presidents? Yeah, it's a good question. Political prosecutions, I mean, criminal prosecutions, we don't have any. So I'm not really sure what a political prosecution is. I don't know any of rules for that, I guess. Fair trial, New York. Washington, Fulton County. No, SCOTUS, I can understand a lot of people are asking about that, but SCOTUS plays the role of an appellate court when it comes to federal laws. So we would have to have final findings and some kind of a law that is being alleged to have been violated in order for SCOTUS to come in, or else they have no jurisdiction. That's just how the Constitution's written. No such thing as political prosecution. Well, I don't know of it. I mean, I'm not really sure what you mean. We've always had political fights back and forth. I get that, but if you're talking about something legal in the legal system, I don't have any knowledge about that. But I'm also just not a political person. So thanks again for your unbiased approach. Oh, you're welcome. You're welcome. You're welcome. I do try to keep it as much unbiased as possible. Just looking at the documents, but also, I just look at it like, well, that's interesting from an academic point of view, as opposed to what the motivation was. So, I tell you, Boxer Mom 2X, this judge, both of the judges, I don't know about New York. I really just don't have that kind of capacity for cases. But with the Florida case and with Georgia, I mean, we've got some pretty green judges. That's not their fault. I mean, that's kind of the spin of the wheel, what happens there. And it's not their fault, but it also is kind of like, yikes. So, I can see why they're going to need a lot of support for sure. This is a definitely difficult trials for both judges, for both of them, absolutely. Where do I practice law? I'm in the Central Time Zone. That's about as specific as I get. I do try to stay pretty private. I've had a couple of problems before, but I'm in the Central Time Zone, which is also where I went to law school. So sure. Oh, sure. Hopefully this was informative. It's an interesting order that she put out. I'm all about, I think it's, when judges kind of try new things, I think, why not? Let's try it. Let's see what happens, as long as we are doing this in the best interest of due process and fair trials. Sure, let's see how it goes. Let's see what works. If it works, maybe judges in the future can do it. But if it's a mess, then now we know what not to do. So, oh, sure. Legality of shipping in people from DC to be members of the Florida grand jury. Ooh, that's not good. No, we can't be doing that. We can look for them. We can look for jurors if we've run out of jurors, but we can't ship people in. That's not legal. We don't want to do that. Oh, no, he didn't do that. Mr. Smith did not do that. But if you have any kind of evidence to support that, feel free to tag me. But no, there's been no evidence or proof of that whatsoever. Yeah, nobody's shipping in jurors. Oh my gosh, can you imagine? Ooh. Oh, for me, show my face? Are you calling me a demon? Oh, no, you can check out any of my videos. I've got lots of videos with my face posted, so you can check any of those out. Just posted one actually this afternoon. Did you already comment on the judgment in the DC case? I did comment. We're kind of going back and forth a little bit, but all that's happened in DC is that the government responded. We're back in DC here. Let me just kind of keep everything clear. Government responded to defendant's response. We have a reply to the response. I know that's driving some people crazy when I'm not clarifying that. But now we've got an order saying you guys need to figure out some dates so we can get together and argue this out in a hearing. So that's what the judge has ordered at this point for DC. But this is Florida. Right. Mm-hmm. Yeah. Oh, no, you can get grand juries all over the whole United States. We get one in, Arizona or Michigan or Wisconsin. We're not limited. In Florida, is the special prosecutor doing something wrong with that and that the judge is pointing out? I don't think so. No, I don't think so. I think the special prosecutor pointed out this conflict of interest because it was their witnesses that they know are being represented by that same attorney. So they brought up the Garcia hearing, and the judge is like, all right, well, defendant, you need to respond to the Garcia hearing question, but also let's bring up these other grand jury questions as well. So let's kind of take care of that. So no, it doesn't appear like anybody's really doing anything wrong here. So far, but we'll see, hopefully. Is this number of consecutive crimes highly abnormal? I don't think so. I think what's highly abnormal is the level of status of the defendants involved. I think that's extremely unusual that we have someone, who's the former president of the United States, and with the DC indictment, we've got senators, we've got representatives, we've got state people. So many people are involved at kind of this high level. That is unusual. But I think the, if there's a whole bunch of batch of crimes that can occur, you can get multiple charges all over the place for it. So, yep. Mm-hmm. Mm-hmm. Yep. Yep. Well, I try, but you have no clue what you're talking about. Maybe, maybe not. Um, Although that would be pretty crappy to just come on live and not have any knowledge, but you can absolutely fact check me. Fact check all of everything I'm saying. Feel free to fact check me on any of it. It will not hurt my feelings. In fact, I highly, highly recommend fact checking me and double checking for yourself. I think so. I think that's important. I think it's good for you to find those facts. Look those up. Yes, absolutely. Absolutely. Yes, well, and sometimes that happens. Why is Judge Cannon throwing the defense bones? Sometimes that happens. It really does. I'm a little surprised because of the magnitude of this case that those would be tossed out. But a lot of judges, that's kind of their styles. They try to kind of help out, just raising issues that maybe they don't think of, or that have been tossed around but not solidified. So it's not that unusual to kind of say, hey, let's make sure everything is on the straight and narrow. Let's cover all of our bases. So it's not that unusual, only that, in a case of this caliber, you wouldn't think you would need to do that because defense counsel would be like all over it already. So that's the only thing that kind of makes me wonder, like, what's going on here with counsel? But yeah, no, it can definitely happen, either in court or via an order like this. Yes, I really don't know what's happening in New Jersey. I think at some point, we've got to. I know there's got to be some kind of a way of figuring out what order things are best done in, on the one hand, but also on the other hand, every jurisdiction is kind of its own entity, so it has its own rules, and they're like, if I've got all my evidence, I'm going to go file. I'm not going to wait for anybody else. So they're kind of their own creatures. So one thing with trying to, get everybody on the same page because we're dealing with the same defendants, but on the other hand, it's also like, I've got my jurisdiction. I need to worry and focus on my jurisdiction. I don't really care about the other jurisdictions, is typically how our prosecutors go forward. Yeah, the Supreme Court would be a court of, it's an appellate court. So if there are any legal issues with federal law, then it would be appealed, but that would be after all trials. So they can't really just intervene in a case. They can't just be like, hey, let's come and talk about the case. They just don't really do that. That's just outside their jurisdiction. Oh, Terry, I think a lot of us are pretty not clear on most of it. For sure. You're not alone on that. It's confusing. It's confusing because of how many things are being filed, how many motions, how many orders, what's being done. Like, this order is very creative, and it could be so creative because everything is kind of moving so quick and there's so much going on. So maybe that's why she needed to make it that way. But on the other hand, it would be, there's just a lot going on. There's a lot going on in both cases. I mean, we have the superseding arraignment coming up on the 10th, but we just had the response order due today, and then tomorrow the counsel's got to figure out when hearings are going to work, and then another hearing's going to be set on the 11th. I mean, it's absolute madness just looking at scheduling, just complete madness. And it's not like Florida and DC are back to back next to each other either. I mean, there's a lot going on. Yeah, I've never seen anything of this caliber before, or anything close to this caliber before, of so many things going on at once. But I mean, again, we have so many, this is just such a huge moment in history. There are just so many things going on. What do you do when your witness gets arrested? Well, you say, hey, what are you doing? Why'd you get arrested? Oh, yes, I think there's this practical aspect of processing it that's going to be one of those issues that they're going to be needing to deal with. Yeah, I don't know that we have any unprecedented political interference I think it's precedented. I think all political interference or political activity in elections has been since, George Washington stepped down and we had multiple parties. So I think that's kind of always been an issue, has been the parties fighting each other. They could, Susan. I'm with you on that. They could just quit breaking the law. True story. I'm with you on that. Oh, I'm glad you learned. Yes. But, and again, I mean, we've only got probable cause showing there's any breaking of the law occurring. We don't have proof beyond a reasonable doubt. We are innocent until proven guilty beyond a reasonable doubt. We have probable cause, though. So there's that. Oh, no. Oh, community college. That would have been cheaper. It would have been a lot cheaper, for sure. I wonder if they do have community colleges for law school. I might look into that. That could be my place where I tell people to go instead of regular law school. Are you able to see what I write? Yes, Teresa, I am. It goes fast, though. It really goes fast. I'm trying to catch everybody, but Florida's a slam dunk case. DC's the most concerning, almost destroyed her. Yes, and I think a lot of people would agree with you on that. Florida seems to be much more, was it labeled? Yes. Did you give it back? No. Okay. Then we've got some problems. Meanwhile, we've got a lot of huge questions involving, fake electors and trying to have the vice president come in somehow and not count the votes. I mean, that's got a lot more elements to it, that are concerning. I mean, if it is proven beyond a reasonable doubt, there's a lot of things that are very concerning here. We've never had a president do these things, and we wouldn't be here if he didn't do this. Well, that's true. That's a true statement. I'm not trying to say one way or the other, but I am saying, we have probable cause. We have indictments. And again, even if we're found, not guilty, we still are going through this whole process because of probable cause. So there's that. But it's crime in DC was taking the docks. Crime in Florida was obstructing. Crime in New Jersey was showing the docks. Yes, although I think there's obstruction also in DC, and the refusal to give the documents back occurred in Florida. But it's kind of tangled up. They really kind of fold into each other quite a bit. I think there's a lot of ways that our tax dollar is being maybe not utilized to the best that it could be. So all hearsay. Well, true. We've got some hearsay elements, but let me just take a moment here. When we go to the Federal Rules of Evidence, we have a rule against hearsay, which is Rule 801, which defines what it is. Now, statements that are not hearsay are statements against yourself or prior statements. But then if you flip, you go into 803, 804, and so on. And so we've got, over 27 exceptions to hearsay that allows for hearsay to come in. So even if it is hearsay, it could still come in under one of the exceptions. So that's just kind of how the laws work with hearsay. So it's a tricky area, but one of those areas that we spend a lot of time on because hearsay can be reliable in certain situations. And courts have recognized that. Well, hello again. Real deal. Welcome. Yep. Yes, I think so. How did she land a case she has no experience to judge? Yeah. It's tough. I mean, it's really, kind of a spin the wheel, and who got picked. It was a random situation for both judges, and not much they could do about it at this point. It was, again, they have ways that they cycle through their dockets and who gets what cases, and it's a random selection process to kind of make it fair. And both of these judges were called up on it. We'll see. I'm not at a point yet where I'm willing to, toss aside Judge Cannon. I'm not quite there yet. I'm like, okay, I think we're still okay, but I think all of us are really keeping our eyes on both of the judges. I think these cases are so huge, we have to. We have to. So, um, yep. Yeah, we do. Yes, I try to not be biased, but this is such a touchy subject for so many people. I get it. I mean, I do get it. But on the other hand, I'm like, I'm just look at the facts. How you decide to make your decision after looking at the facts, that's up to you. That's not my choice. That's your choice. True. Now, only one of those judges has been overturned already. That's true. And the only thing I have to say about that is that, a lot of our new judges that haven't been on the bench, they make mistakes. And, I don't know what her motivation was. I don't know what that was, but she made a mistake and she got batted back down by the higher court. And, that's kind of a rough moment for any judge to go through, is when you're told by the judges, like, you screwed up. I mean, that's a learning moment for everybody involved. Hopefully it won't happen anymore. But again, it's one of those learning moments that's excruciating. What happened to all the indictments in New York? Isn't he still waiting trial there as well? Yes, he is. And I just don't go through the New York charges. There's a valid grand jury indictments going on there too. The content of that particular set of indictments is just not something I'm willing to dive into during my free time. So I really just stick to the Florida and now DC case. And if anything does come out of Georgia, I'll probably go into that as well. But kind of the facts of the case, of the New York case, to me just are just not something I really want to spend much time on. It's just, again, we've got probable cause, and I understand we don't have proof beyond a reasonable doubt, but I'm just not wanting to talk about hush money and campaign finance. It is complicated. New York is very complicated. It is. There are a lot of things going on in New York. There are several there are several TikTok creators that kind of dabble in it, and I think they do a really good job. But I just can't keep it all straight. I think if I added New York in, I would just be bonkers at this point. Canon sua sponte questioning the jurisdiction of the grand jury was surprising to you. Yes, Atticus. Yes, I agree. And it was a sneaky sua sponte. It was sneaky. And the way that she presented it, I'm not sure we could fully say, this is just coming from the bench. It's more kind of like hinted at. So it's not a full attack, but yeah, it is. It's a little bit different. It is a little bit different. I would agree. It's unusual. This is your free time. We are all insane here. Yes. That's okay. That's okay. Yeah, that's fine. We're all a little different, aren't we? Waiting for me to read the Mueller report. You may be waiting for a long time, Inez. You may be waiting for a very long time for that. Although I do have it printed. Well, hello, Paralegal Life. Welcome, welcome. I do have it. I have read it, but nope. I'm not. That's probably not something that's I think would be very helpful. I've read it. It's a pretty dry read. I mean, it's good to know, but it's pretty dry, I guess. I imagine New York would be super hard to explain to the people who don't know the law. There's a lot of nuances that are involved with that when it comes to campaign finances. But there's a lot of weird stuff going on with campaign finance, and it's uncomfortable. And I think ever since we had the FEC case, Assistance United case, it's just been a lot of uncomfortable things that have been going on with campaign finances for everybody, for all campaigns, not one party or the other, but for all political campaigns. So it's disturbing. It's frustrating, I think, to some degree. Extremely dry read. Yes, it really is. It is. Like, that's not even something for falling asleep. That's something like if you need to go into surgery, you read that and you're out. You don't even need medication. You may be interested in the bribery acts and amendments. Oh, really? Okay. Interesting. I could take a look at that. Oh, thank you, Manuel. Appreciate that. What did you get out or the Mueller report besides it's a dry read? I think the information that came out in the hearings was, that was one of my favorite things was watching him testify, because the look on Robert Mueller's face when he's got all these Congress people asking him questions, he's just looking at them like, why am I here? What have I done with my life to get to this moment? And so I found that I found that fascinating. He's like, it's in the report. Read the report, people. I don't know. Read the report. It just cracked me up. But I think a lot of details that we didn't have before came out, and that was very helpful, very interesting. Extremely fact heavy, which is always helpful. It was a very good investigatory document, and it led to a lot of convictions. So I thought that was helpful. Raise your hand if you didn't have to Google sua sponte. It just means of the court's own accord. I'm sorry, cheesecake. Oh, sorry. I'm sorry about that. Forgive me. It means on the court's own accord. So by themselves, the court decided to do something. So we would call that sua sponte. That's the legal term. Oh, you know what it means. Well, yes. I'm sorry for anyone, though, that didn't. I apologize. Oh, my goodness. I try to keep things real here, so my bad. Sometimes I forget what I'm doing. I do have a YouTube channel, or a Tube of You channel, under the same name, and so you can go back and take a look at any of the documents. I did go through the documents that were filed in DC, along with the order, as well as this new order that just came out of Florida. So I did go through those. You can check those out and kind of fast forward through anything, and that might help you fall asleep also if you're not up for the full Mueller report, so it could help with that. This new order, just to summarize, just to see if I can do this in 90 seconds or less. We have a question that was raised by the special counsel on Stanley Woodward Jr. He represents 3 witnesses the government's going to call to testify, and these 3 witnesses are represented by him, but he's also Mr. Nada's attorney. And so there's this question of, is there a conflict of interest? We don't know. So they were asking for a Garcia hearing, which is a hearing to talk about whether or not it's a conflict of interest. Mr. Nada has a chance to respond to that, and also, to support this conflict of interest, the government had filed a couple of documents. They filed them sealed. The judge said, you don't have enough support to say these need to be sealed, so she denied that and struck those 2 sealed records from the docket. Next, she said to Mr. Nada, what's your response to Garcia? We need to have a hearing on that, or are you fine with it? What's going on? Also, while you're at it, let's look into the legal propriety of using out-of-district grand jury proceedings to continue to investigate. And then not only for Mr. Nada, but the other defendants could, if they would like to. And none of this further investigating into the grand jury issue is going to affect any of the motions regarding the indictment and if there's anything wrong. So there's that. Did I make it? Was it 90 seconds? I think it was, maybe less than 90 seconds, but that's the that's the creative order that came out of Florida today by Judge Cannon. Well, we'll see. Oh, thank you. We will see what happens with Judge Cannon. I mean, she's definitely, all eyes are on her for sure. That the judge was wrong. I don't know that the judge was wrong. I don't know. It's creative. She's definitely kind of suggesting to defendant and defense counsel, like, hey, there might be a question here. Go ahead and bring it up. But we don't really know why. She could have motivations for just kind of keeping everything on track or keeping everything tidy for her docket. Not really sure. So can't you request a change of venue? You can, but you really need to have a good reason to. Those things are definitely, something that's argued about. And we've already gotten so many things started in the Florida case that it would be quite the hassle to move it. And in DC, for change of venue, I think the argument is, hey, everyone else has been tried in DC that was part of January 6th. So, why not keep going forward on it? So, and I think that's a valid question for that. Judge can't give legal advice. True. Yes. And that's why I think, her language here is light. I don't know that this would rise to the level of legal advice. It's just she's kind of hinting at it, or just saying, hey, we've got this other issue here, so let's just talk about it. How she's handling that, I don't know. It seems we're walking a line here. I don't think she's crossed a line, but I think we're walking on the line. And so that can lead to some questions. Yeah, it's leading, but leading can be allowed. Leading can be allowed in some situations. So, that's, again, we really have to have some kind of a true violation of a rule, or too much of a conflict in order to kind of go forward. She's trying to tiptoe around that line. I agree, Daisy. I think there's some tiptoeing going on. I think that's a good way to describe it. I don't think we are in a danger zone, but I think we're kind of like, that's probably a little closer than I would want to go. But again, I'm not the one dealing with it. So a time issue, it could very well be. And we have a lot of time issues going on right now. So there are a lot of issues. Everything seems to really be coming to a head right now. There's really a lot going on. Right. Ocean spray. Right. We don't know what goes on between counsel and the judge. And, I think it would be odd for a judge to just be sitting around and say, oh, well, what about the grand jury issue? I mean, there's somehow that must have been brought up somehow and in some way, but we don't know how that was. But it was of an importance. She felt she wanted to put it into her order. So, there must be a reason for that. She must have a legitimate reason for why she actually set this out in her order, rather than just saying to them one way or the other. Highway to the danger zone. Yes, it could be. It's a gateway. It's a gateway to the danger zone. It's possible I believe if DC gets real, she will backpedal. That could very well be. I think that we're definitely juggling this situation right now. What would you do to counter this if you were Jack Smith? Well, I don't think there really is anything to counter. I don't see any legal issues with this grand jury question. I think she's, I would say, you just go, you address it. He's going to, as a prosecutor, your job is to figure out all the arguments that defense is going to raise and then make your case to argue against it. So he's going to come out and he's going to say, well, what are defense counsel going to say about out of district grand jury? And then how can I argue against that? So this is a heads up for him too. He's saying, she's kind of hinting here that we need to take care of this. So I'm sure they're probably already like shoulder deep in research on out of district grand jury situations. So they're probably already putting everything together. Oh, welcome back. Welcome back. Oh, you're caught up. Good. Everything is subject to scrutiny since it's such an unprecedented case. Absolutely true, Norma. Yep, you are correct. This is recusable. Maybe. I'm not sure it rises to the level of recusal, because that really is kind of a high standard. And, it really is. I could see how this could be a factor in the future, but I'm not sure it would really rise to that level. Does this give Smith any ammo for asking for her removal? I don't think so yet. I don't think this alone, because many times our judges will kind of, bump over to the defendant like, hey, take a look at this, or hey, did you deal with this issue, or hey, when are you going to draft whatever? I mean, sometimes that happens, and judges will do that. Again, our number one concern is that we have a fair trial for the defendant. It's the defendant against a 600-pound gorilla, which is the government. So we always want to make sure our defendants are protected and taken care of properly in the judicial system. So, she may have felt that this kind of language, these hints here, were really necessary. So it's, it could be justifiable for her. And I can see both sides. Can you imagine being a law school during this period in history? Oh my goodness. I know. It's just fascinating. I mean, academically, I understand that it's painful for everybody, of course, but academically, from a legal point of view, it's absolutely fascinating. But shouldn't his attorneys do that, not the judge? Yes, Michelle, absolutely. They should. That's another thing. Usually when judges kind of lob something over to defense, it's because defense needs the help, not when we're dealing with a high caliber case of this level. We usually don't see those kinds of hints. They're not really needed. But for some reason, she just felt it was necessary, and even to the point where she specifically put it in her motion. So must have had a reason for that. What do you personally predict will happen in Florida with the Florida case? Just what the world needs. Well, yes, true, George. We're like, cockroaches. We're everywhere. There's no getting rid of us. Yes, pitches in a live. Yes, it is. It really is, I think. I kind of think it is. Yeah. And, it happens, though. It's something that we definitely do within our system. We are all victims. It feels that way. It kind of does feel that way. To some degree, absolutely. I mean, again, from a legal academic point of view, it's fascinating. But if you step back and look at what all of this means, it's pretty horrific for everybody involved. So, which is unfortunate. Yep. Yes. Oh, the cockroaches. I know. That's not very nice of me to say ethically about my fellow attorneys, but we're like bad pennies. Maybe that's a better way. We're everywhere. We're everywhere. There's no getting rid of us. You get rid of one, another one just pops up. Can all these court cases prevent or slow down from running next year? At a minimum, the amount of time and effort and energy that it takes to go through this process, like if you put everything aside about Mr. Trump, if you put it all aside, and I know it's hard to do that, but if you set it aside and you say, here is a man who is being charged, and we'll just use the 3 federal cases, who's being charged with all of these offenses in New York, all of these offenses in Florida, all of these offenses in DC. Even if he's found not guilty on all the charges, hypothetically, I mean, this man is going through the ringer with these huge federal cases. Now, I don't say that for sympathy. I just say, as a practical matter, if you're putting a human being through this level of criminal cases, it's going to take a toll on you. It just is. It would be impossible for it to not take a toll on you. So because of that, you're not going to be performing at 100% for everything else that you need to do. So, I would say, yeah, it has to have an effect. It absolutely would have an effect on anyone. And again, I'm not trying to pick a side here or anything like that. I'm just saying, just as a human being, it's a stressful situation. Now, is it a situation that he created? Yes. According to the grand juries, it is at a probable cause. Issue raised by the judge may be jurisdictional, which may be why she raised it. It could be. That could be. I wouldn't say that that's not possible. It definitely could be something on the table that she needs to consider, that she needs to take into consideration. And again, at this point, we really don't have any information saying that, this judge can't do her job. I think we're not there yet. It's possible in the future, but I don't think we're there yet. And a financial situation too. Court and lawyers are expensive. They are. And even as a lawyer, having to talk to lawyers all the time, like he's probably having to talk to his attorneys all the time. And again, I'm not trying to pick anybody's side here. I'm just saying the actual process of going through litigation at this level is, it's exhausting. And it takes a lot. It takes a lot. Oh, sure. Yes, and his lawyers need to be lawyers and a defense counsel. And that's, that's their job. That's what they are supposed to be doing. And maybe he does. And again, we've got our grand juries coming in and saying, hey, you do the crime, we're going to indict you on probable cause. And that's what they've done. So it's not like it's not legitimate, But just again, from a practical perspective, going through this level, I would say the same thing about anyone going through these kinds of cases. Even if looking back at the O.J. Simpson cases, with the homicide and the civil case, that was a lot. That was a lot for him. It's not a sympathy. It's just an acknowledgement of what was going on with his person at the time. True. Absolutely nobody is above the law. Absolutely. Oh, and family support. I think that's also another huge issue. I think anytime anyone goes to a criminal court, it doesn't matter what the case is, you kind of figure out who your real friends are. And that's just kind of the nature of going through the criminal justice system. Yeah, his lawyers do end up needing their own counsel. I mean, it's a lot. It's a lot. Do I think any of the indictments are legit? I think for our grand juries to come in and find probable cause to indict is absolute justification for going forward on a trial. It absolutely rises to that level. Will there be proof beyond a reasonable doubt? Will he be found guilty at trial? That I do not know. But to have enough information to set these indictments down, I think it is appropriate that we go forward with a trial and pull in a jury and let the jury be our fact finders and figure it out. Figure out what happened here. So, again, we've got these jurors don't have anything to gain. They're just coming in to kind of to do their job. And, they made their decision, and that's how we go in that situations. And juries go back and forth. With grand juries, it depends. Some of them, what I will say about grand juries is they take their job seriously. Whether or not they choose to indict or not, you just, it's hard to really know, but they take it seriously. So, and he may be found innocent. That's true. It could be. He could be found innocent. We do not have the information. They could have political motivations that are not mentioned. True, Brax, and you're talking about the jury, I'm assuming. And all I'll say to that is that we are very rigorously trained in picking our jurors and try so hard to find non-biased people as best as we can. So I think we do the best that we possibly can with what we've got to work with. Why are you leaping from grand jury indictment to the trial? You forgot the part in between. Well, I think I use a grand jury versus a trial to show the different levels of evidence that's required. A grand jury level of evidence is much lower than a trial level of evidence. So for our indictments to come in, does not mean that we've got a conviction on the way. So that's why I use the trial jury versus the grand jury to kind of explain that we just have two different things. Am I a Democrat? I have no political affiliation when I sit down and talk about the law to people. I have none whatsoever. Wouldn't want to be an attorney on this case. Yeah, it would be tough. It'd be pretty exhausting, I think. I think any of our super high-level cases, oh my gosh. I mean, just even a run-of-the-mill, plain vanilla case, consumes your entire life. But something of this magnitude, I mean, no one's going to be sleeping for years here. So absolutely no possible way that these people on the so-called grand jury are extremely biased. Well, Josh, I don't know that there's no way for that. I think everyone has some bias to them. I think that's absolutely possible. But what's required of our jurors isn't that they don't have any bias. What's required is that they can still be fair and impartial, even with the bias. And our jobs as attorneys to weed out the ones who we know cannot be fair and impartial. And we get rid of them. We move them to the side, and then we move forward. So we all have some kind of bias. We all do. Everybody does. You can't get rid of it because we're humans. But even though you may be biased, you still can be fair and impartial. So that's really the backbone of our justice system. Why do you treat a grand jury like they are different than a trial jury? They just hear one side. they are different than a trial jury because they only hear one side and they only need probable cause. So they are different. Our trial juries are fact finders. They hear both sides and they determine which witnesses are credible, which ones are not credible. And then they come back and they decide what should happen. Is the defendant guilty or is the defendant not guilty? So our grand jury, our petite or petit juries are two separate entities, both incredibly important. So I wouldn't say one's more important than the other. They're just different. Explain voir dire, because I don't think some of these folks understand how a trial jury's picked. Okay, sure. Law of the Wild, welcome. Voir dire is a process, and it technically, I think, translates into speak the truth. And it's a process where we go through several sets of questions with our potential jurors. We have questionnaires that they fill out before they even come into the courtroom. They fill all of those out, and everybody, both sides, look at all of them, including the judges. And then when they're called in, if we are going to go to trial, we have a huge batch of them and people that will come up, and we start asking them questions. Now, our job as lawyers is to find people with bias that we know will not be able to come and be impartial and be fair, and we want them gone. We don't look for a juror that's going to hold for us or to find for our side. That's not our point. Our training is to find someone who is impartial, not someone who's going to rule for me. That's not the point. So when we go in, we try to ask questions to really pinpoint out where these biases could be. And a lot of these questions would be something like, to the whole pool, we'd say, does anyone here have a family who is in law enforcement? Does anyone here have family who's in the military? Does anyone here know the defendant personally or know the defendant's family? Or has anyone had a negative experience with law enforcement or negative experience with the prosecutor? We ask these kinds of questions to really hash out where these biases are. There are some cases where if the defendant's appearance is an issue, we would ask questions like, my client here is kind of a heavier kind of guy. Is this a problem for any of you? I mean, you try to say it in a way that's better than that, but you would say that. You're like, so, is his appearance something that would make it so you feel like you wouldn't be able to follow the judge's instructions? All of these kinds of questions, we really formulate and put them in a way to kind of pull those kinds of answers out. And of course, all of them are under oath, all of our potential jurors, and so they need to answer truthfully. And over time, we will be removing potential jurors until our box gets smaller and smaller, until we get a set that we can start going forward on. So it really is a very intense process. If you do criminal work, if you're a prosecutor or you do criminal defense, we get trained on it. We're trained very intensely on it because it's a huge part of our job. So I just went off on that for a little bit. What about a juror's disability? I'm deaf and I got called for jury duty. We should have accommodations for any of our jurors with disabilities. We've had many cases where we've had jurors who have had different kinds of like fibromyalgia, so they can't sit for very long, or they have a vision issue, so they can't necessarily see the documents. So we just get accommodations for them. We take lots of breaks if the juror needs to move around or walk around or do whatever, or we get special visual aids in order to help, or hearing aids, whatever it is that we need in order to accommodate that. We don't use disability as kind of a litmus test for, this juror needs to be struck, because, we could have a juror who would be an absolute amazing impartial juror and have a disability, and all they need is an accommodation, and then they'd be a great juror for us. So we have to look into that, and we do have resources to accommodate that. So I think that's really important. That, again, the goal is to get the most impartial juror that we can find. So if that impartial juror happens to have a vision disability, then we need to accommodate that. Oh, it most certainly is not foolproof. Absolutely. True. It's not. Most people don't know there is ADA laws. True. But our judges do. And our judges tend to be extremely understanding with our jurors. They tend to be. Again, I can't speak for all judges, but in my career, I've always seen our judges be very kind, understanding to our jurors. Just don't watch Fox News. Okay. They even let women on jurors. I know. They do. It's crazy. Judges can be biased, true, to some degree, but they can also be held accountable. Hopefully they are held accountable if there's an issue. So hopefully. That's definitely gotten better over the years. I mean, 15 years ago, oh my goodness, it was a mess. But are there questions that are not allowed to be asked when screening jurors? Our judges are very flexible, and with attorneys, they tend to give us a lot of leeway to really kind of get into those issues, very sensitive issues. But if we have a sensitive subject, what we tend to do is ask a general question to the whole jury pool that's been set out. We'll ask a general question. We'll just say, hey, these are some very sensitive issues. Does anyone here have a problem with a crime that's of this sensitive nature? And then we will wait for like a hand to go up or some kind of a nod, or we'll ask, can you nod your head or can you write down on the sheet of paper if you've got a problem? And so what we'll do then is we'll take that individual juror, and it could be the prosecutor and defense counsel. We both will go in with that juror into chambers, ask those private questions in front of the judge, and then work through that so that that juror is not exposed to the whole rest of the jury when they're being asked these questions. So if we've got questions of that nature, we can kind of pull them back into chambers and do that. But other than that, we just try to be respectful and careful when we're asking questions, but we also, have to really get those bias issues out. And sometimes that can be like, does it matter what race this officer was? Does it matter that, this person was doing this particular activity at the time? Is this something that's going to bother you? Those kinds of open-ended questions just need to be asked. Oh, well, thanks for coming, Norma. Thanks for coming. Yes. Yep. How long will jurors serve? It depends on your jurisdiction. It can be a couple of weeks. It can be, you're kind of on for 2 weeks, off for 6 weeks, back on again. So it depends on how your jurisdiction is set up. Oh, thank you so much. Yes, and good night to you as well. Good night to you as well. Thank you for stopping by. I appreciate it. For these cases, I have no idea. Even I think the process of picking a jury is going to be very, very long. This is going to be a very difficult, long process of picking one because we have to just be so careful. So there'll be a lot involved. I don't know. I would say typically a complicated jury, if I've got a homicide case, if there's a complicated situation, it could be, 3 days, 5 days a week at the most, and that would be super complicated. But a case like this, I wouldn't say, a few weeks. We could go into it for a few weeks and try to get these questions and bring in more jurors in order to really whittle everybody down. Yeah, it would take a really, really long time. Yes, good to see you too. Well, yes, I'm so glad you could come by tonight and have a fantastic night. What made you decide to come to TikTok to educate the public? Well, it's very simple. Actually, I had a very, very, very dear, sweet friend, and she passed away, and her daughter was in high school and had asked about law school and what the legal field was about. And I said, well, we can sit down and talk about it, but that's boring. So I asked her if she was on TikTok. She said she was. And I said, well, I'll make you some videos, and just kind of took off from there. So I just kept making videos and trying to answer questions that I thought she might have or find things that she might think were really interesting and share those so that she could have that information and knowledge and make that choice to go to law school or not. So that's really why I got into it. That's really it. For just a dear, sweet friend of mine, for her daughter. So I keep coming back. Well, thank you. Thank you very much. I do try. I do try. Yes, I'm thankful if anyone can find information or ask questions. Hopefully that's my goal, is to not necessarily have everyone feel a certain way or think a certain way, but to start asking questions. I think that's the best way to do it. Yes, it was breast cancer, and that's unfortunate. But I learned so much from her. It was a blessing to have known her. So, yep. Yes. Well, thank you. Thank you very much. Thank you for that. I appreciate that. Yes, you have a great night too, Michelle. I probably should get to signing off as well myself. I think this was my yeah, I think I've gotten through to, to everything. Oh, that's okay. Yes, I will put it up on my Tube of You channel shortly thereafter. I've got actually a couple of these. Oh, I know. I know. I've got a few more minutes in me still, but yes, I've got this one, and then I've got another one that I did earlier today. So I'll put both of those up on my Tube of You channel for anyone who wants to kind of can't stop. Neil, you're hilarious. Oh my goodness. Oh yes, but I will have it up so you can kind of go through it and fast forward and kind of figure out what's good, what's interesting, and what's not. So I will try to do that. What's my thoughts on people who violate the Fifth and 14th Amendments? I don't know. I think a violation of any amendment is something to take a look at, I guess. Thank you for your service. You're welcome. Oh, you're welcome. Absolutely. Oh, absolutely. Thank you, Desert Skies. It's so good to see you. When you pop up, I really appreciate it. Yeah, this isn't really a First Amendment case. I think that defense counsel, oh, thank you. I think defense counsel has to be defense counsel. So they have to raise these issues. They have to bring up whatever they possibly can. That's their job. Absolutely is their job. So they must do that. And even if it's not going to shake out in the end, I think they have to bring those questions up. Yep. Yeah, what's the verdict? Yeah, we got to have the trial first. It is. Yes. Oh, and to you too, Suze. Thank you for that. Very, very kind of you. I appreciate that. You're welcome. Yes, I'm just looking again at the clock. Like, I swear I try to keep my lives shorter, and every time I come on, I tend to go a little bit longer. I think the Florida case is significantly stronger than the DC case. For me, they just are two completely different animals. I think the Florida case is just, were the documents labeled? Were they not given back? Okay, let's go forward. Versus, was there a government proceeding? Yes. Was it, infringed or obstructed upon? Well, let's take a look at that. So I think it's really just apples and oranges. I do. I adore you all. I do. I just love the questions. I think it's great. So many smart, great, talented people out there. But yeah, I think they just have two different levels that we're dealing with. Yeah, they did. They did bring up that First Amendment, and even in the government's motion against the protective order, he said the very first sentence was, the government's trying to hinder First Amendment. So, yeah, give me all your money. That's your political speech. Yeah, right. Exactly. Or, why don't you drive the car while I go in the bank for a minute? Come on, we gotta have some limitations. We can't just go shouting fire in a crowded room, right? So there are, but First Amendment's, I think always that kind of catch-all. Why not say the First Amendment? Why not try to use that? Go for it. You gotta do your job. You gotta find whatever defense is humanly possible. But yes, there are limits on free speech. There are, absolutely. And, when it comes to criminal actions, there's definitely limitations. So, yeah, and I think they really address that. I think it'll be interesting to see what happens with this hearing that they argue on the protective order, and to see what both sides are talking about. So I think it will be very interesting to see what all comes out there. But the government's attorneys are probably frustrated with trying to make this First Amendment argument, because I don't know how you argue one of the basic tenets of law. It's kind of like what? What are you talking about? Nothing of what he said is illegal. Well, I think, there's I don't know. I mean, what he's being charged with is for obstructing a government proceeding. And part of how they're saying he obstructed it was by his use of words. So, if it was obstructed is because he said to people to obstruct it, that's could be the argument there. There are a lot of very interesting discussions on freedom of speech. George Washington was there. We also have Thomas Jefferson wrote a very interesting piece. I think it was called like the Southern First Amendment, something or another. And he went on, which was very interesting. And actually, the Brandeis Brief, which is very famous legal work by Justice Brandeis when it came to the First Amendment, all excellent, interesting arguments when it comes to that. So yes, I think so. I think we all have kind of our own biases and reasons why we think there are motivations, and then we've got what the law says and how the law is being utilized. So yes, and the argument the Supreme Court will get involved. The Supreme Court's jurisdiction in any federal case is as an appellate court, so they can review any kind of questions of violations of federal law after a case has already been decided. So they can't just swoop in and be like, hey, we're here, let's talk about it. They don't. That's outside of their jurisdiction. So they have to follow jurisdictional rules. And I'm sure Justice Alito would agree with me on that. Got history and tradition, Justice Alito. Oh, you gotta follow that. Yes, exactly. We are trained ad nauseum to look past them. We really, really are. That is a beautiful way of putting that. That is exactly right. Yes, it has to be proven beyond a reasonable doubt. Absolutely. That is the standard that must be done. It must be proven beyond a reasonable doubt. Absolutely, in criminal trial. We've got to do that. Do these documents get auto-generated to some extent? I think there's a lot of boilerplate language that's already in a lot of these documents, but I think a lot of this, particularly like something like this order from Judge Cannon, the way that she set things out here, this is unique. And so this does not look like boilerplate information to me, but there are some examples and templates that they use for a lot of that. Can we go through real case law next? I'd like to. I've been looking at my case law. I didn't make it through the Heller case yet. I still have half of Heller to get through. So I keep trying to figure that out. I've got to figure my schedule back out. I kind of got thrown out of my normal broadcasting schedule. So, but I am putting it together. I've got several cases that I would like to share and go through. So I will have those on the docket here pretty soon. I should join you for Heller. Ooh, that would be interesting. We could do that. We could do a joint session on the Heller case, or McDonald, or both. We could do both. That would be fun. I mean, fun for me. That would be fun, academically fun. But yeah, let me take a look and see what I've got going on. But I think that would be interesting. Yeah, I think the First Amendment is just misunderstood. It's misunderstood. All this is fun. Oh, how kind of you to say that. Oh, really? Second chair. Oh my goodness. Wow. Oh my gosh. I will have a new perspective then when I finish going through that case. But yeah, I've got to set that up. I've also got Dobbs on my list to go through with Roe. I know a lot of people wanted me to go through Roe v. Wade and the Casey v. Planned Parenthood case. So I wanted to put those together along with the Dobbs case. I've got that, and I've got my Second Amendment cases. So I've got it. I've just got to kind of get things sorted out, get my schedule sorted. Oh, Cameron Diaz. Oh, that's nice. Thank you. I'll take that as a compliment. Appreciate that. for sure. But I'm taking a peek here at the time, so I think I will go ahead and sign off at this point. Thank you everybody again for joining me. It's always very interesting. I'm thankful for the time that you take out of your schedule to listen. A lot of misunderstandings about Dobbs. Absolutely. Yeah, it's not about, it's the Dobbs case is a Ninth Amendment case, and it's all about, honestly, it's about Glucksberg. And so I think that would be very interesting to talk about. So I will put that on my list. Yes, you're welcome, everyone. Thank you all again for coming. Yes, good to see you all. This will be up on my Tube of You channel again. Here, I will upload it here in just a little bit. If you want to listen to the documents and see what's going on. So, oh, yes, thank you. Yes, you're welcome. Oh, my pleasure. A few guitar chords. Not tonight. Oh, not tonight. Maybe sometime. I might. The name of my Tube of You channel is the same as my TikTok name here. So, it's just the exact same. You can just hop on, and it's very simple. It's just, honestly, I just upload my lives to it so people can go back and refer to it. If I set a case name or so on, I've got a few of my other lives on a few of the other cases I've done. So, people seem to find that to be helpful. So I just put them up and make them available for anyone who's interested. So, I've been thinking about doing lives there. I've not made the transition yet. I'm kind of sorting through how I want to do it. So, we will see. Oh, thank you so much. Thank you. Yes, I do. It's very simple, nothing special, but I do just put my lives up there for anyone who needs help going to sleep. I can do my best. But anyway, so have a wonderful night, everyone, and thank you again for joining me. I appreciate it. And if we see any new motions or orders coming down on these two cases, I will let you know and explain them as soon as I get them. So take care, everyone. Have a fantastic night. Yes, you're absolutely welcome. Good night. Good night, everyone.